Hello, I see Lavanya is here. How are you, Lavanya?
I'm fine, thank you.
I'm excited about your presentation tonight. I want to welcome everyone, first of all, to this BarMax 1L workshop. I'm Celeste Pagano-Bowles, and I'm the content director at BarMax. And I also head up a very talented team of instructors, including Lavanya, in providing a comprehensive bar course and tutoring to those who need it. But you guys aren't here for a bar course. You're here to learn something really important about your 1L exams so that you don't make the very common mistake of thinking that just knowing the law, studying really hard and knowing the law really well is going to be enough to do well in your 1L exams. I have to say, I made that mistake first semester and wish I had listened to someone telling me the information that's going to be in this presentation. So you guys are in for some real help, and watching this will put you at an advantage. We say 1L doesn't have to be, it's our first year law students sort of study aid and materials. And it is now available for free for those who enroll using this link. So Katie's going to go ahead, I think, and throw that link into the chat. It's testmaxprep.com/1L/unlock. So then you'll have access to it. It's really helpful. It has a ton of legal case briefs from case notes. It has the Emmanuel Law and a flashcards. So those are not BarMax created materials, but we've assembled materials that we think you as a first-year law student will find helpful. What it also has is our lectures, and these are our bar lectures, but they can be helpful if your professor isn't being clear about something or you don't understand how it fits. You can listen to that section of one of our bar lectures now early and get an idea of that section of contracts or that section of torts or whatever it may be. So that is helpful. And as Lavanya will talk more about later, you can also do practice essays within this product. And maybe I can even come back and show a little later on what that looks like. The other thing we offer, of course, is tutoring, law school tutoring. For those who decide that, I'm going to get a little extra help. I'm going to get help from a highly qualified tutor. Some of us, including the two of us here in this call, are former law professors ourselves. So we have worked with first-year law students and upper-level law students both, and can, target what's going on. And we have other highly qualified people on our staff. And if you feel like BarMax is something you're already getting excited about and you want an opportunity to learn about, a chance to even get a free enrollment in BarMax, that is a free bar review course, you can apply to join our rep team, and the people selected get free bar review. So that's another link, and that's a way more complicated link. I'm not even going to try to say it. But if you are interested in maybe being a BarMax rep on your campus, maybe you used LSAT Max, so you know that our products are really good and streamlined. We have just a simpler and less stressful way of preparing for the bar than some other companies out there. And we think that's going to be a great fit for a lot of you. If you think that's you and you want to be on the rep team, please get that link right now and go fill out that form later as your application. So Lavanya, I know you have the same presentation, but maybe you want to share it on your screen, or do you want to Yeah.
Yeah, I've got it all set up to share on my screen from this point on. So
Good.
that
I'll
way I
jump
can.
off my screen and we'll let you take over because I know you've prepared this fabulous.
Okay, great. Well, I'm really glad to be here with you this evening. This is the type of webinar I wish I had had my 1L year. And I currently tutor bar students, but I used to teach all levels of classes from pre-1L all the way to 3Ls. And the one comment I used to get from 3Ls all the time was, wow, I wish I'd known this stuff my 1L year. So here is your opportunity. I'm going to teach you some of the ins and outs of handling essays on the exam, and you're getting the benefit of it now instead of your 3L year for your bar prep class or in bar prep after you graduate. So let's just go ahead and get started. Take a look at this. I think I'm sharing my screen. Can you, let's see. Are you able to see the screen?
We are not, sorry.
Okay, hold on one second. Let me do that. See how to do that. I should probably hit share screen. That would be helpful. Okay. Here we go. All right. So this is the 1L workshop, Mastering Law School Essay Exams. And a lot of your exams will be primarily essay. You might have a great teacher who's going to also give you some multiple choice, but today we're going to concentrate on essays. Are you able to see my screen now?
Yes, indeed. Yes,
Great.
we are.
Okay, great. I should have checked that. All right. So what is the objective on these essay exams? The objective is you need to be able to identify what rule or rules of law is raised by the facts or the set of facts. That really means identifying and properly labeling a majority of the issues on your essay exam. And that'll probably account for a good chunk of the points on the exam itself. Okay. So what is the strategy? So I was a poli-sci major, and I came into law school with, wow, I'm going to learn as much, memorize as much as I possibly can, and write as much as I possibly can. So that's not what you need to do for these essays, your essay exams. You can't go with how much can I write approach. You actually have to have a plan of attack. Remember that you're training to be an attorney, so your whole job all day long is solving people's problems. That means listening to their concerns and then coming up with solutions and advising the client. That's what these essays are meant to teach. And really every essay, even every multiple choice question actually, is a client coming to you with a set of problems that you need to solve. Okay. So the more fact patterns and legal rules you associate together with each other before the exam, and that requires practice, the better you'll perform on the essay. You can associate fact patterns with legal concepts really by practicing the questions. That doesn't mean you don't have to learn the rules in your outline, but just memorizing the rules isn't going to get you where you need to be. Okay. I used to think this, my 1L semester, that if I memorized all the rules and then repeated them on the exam, that's really what the law school essays were testing, how much I could memorize, because there was so much information. But really what they're doing is they're testing your ability to apply the rules to specific sets of facts, and most importantly, solve the problems. What about all these cases you've read all this semester for all of your classes? They are very important also. You need to know the facts of the case so that you can recognize similar fact patterns on the exam, because elements of the cases might show up in one big essay. You also need to learn, they also teach you how to use the rules correctly. Okay, so how are you going to learn all of these rules? You can't know every single rule, but you can start to memorize them and know them by writing them down. The more you write down, the more likely you are to pass. This requires memorization actually progressively through your course, as well as preparing, like starting to prepare now by memorizing many weeks prior to your exams, because you just can't tell huge bodies of information. It's really hard to learn and sort of cram at the end. So this is critical. Even if the exam is open book, don't fall into the trap. It's critical that you memorize at least the major rules, because you won't have time to look up every rule. And actually, without the rules and knowing how they work, you won't be able to identify the issues. Okay. So you need to allocate time to writing rules you come across while studying and reviewing essay questions. That means the ones you recognize, and more importantly, the ones you didn't recognize in your practice. Don't just read the rules. That's passive learning. Make sure that you write them down, and that means you're interacting with them. It's going to make them easier to learn and understand and memorize. If available, practice using your professor's old exams. I know a lot of law schools have, in the library, they have archived professor's exams. Practice with as many of those as you can so you can understand the professor's style of asking questions. Now, the nice thing is that with the BarMax materials, you also, I believe, get a limited number of essays to practice. So if a particular professor in a topic doesn't post them, you will have access to those to practice with. We're going to talk about this a little bit more in detail, but when writing a rule, think about which words are most important, because certain rules have certain buzzwords to them. Okay, what are the steps for answering an essay question? So step 1, read the call of the question or questions carefully. Try to figure out what they're asking you. Step 2, you're going to use the call of the question or questions like a mirror, meaning that you're going to use them to leverage your ability to organize your answer. After that, step 3, break down that mirror into smaller parts. And then step 4, use an IRAC pattern of writing. That's issue, rule, application, and conclusion. Step 5, be obvious about your answer. Right. One of the best ways to learn, I always like to teach by example. So let's just take a look at this fact pattern. So husband listened in on wife's call on an upstairs extension of their home. He overheard a conversation between wife and man during which they discussed a love affair they were having. Husband became furious and consulted with broker. He gave broker $5,000 to hire unknown third party to kill man by arranging a quote unquote fatal accident. Broker contacted mechanic. Broker gave mechanic $1,000 to adjust man's steering mechanism so that when the car was driven over 50 miles per hour, man would lose control of the car. Mechanic made the adjustment. Man's son, borrowed the car and en route lost control as a result of the adjustment. He struck a car driven by doctor. Son was unhurt, but doctor died as a result of the accident. So that's just 2 paragraphs, but there is a lot going on. So you can't just start thinking of all the rules in your head and start writing. You have to have a plan. So now we read the call of the question. What crime or crimes is husband guilty? Broker guilty? Mechanic guilty? Okay. So what we're going to do is use the call of the questions to go ahead and try to see if we can set up an outline for answering, for the basic outline for answering our question. So if you're given different parties and a number of potential issues, use the call of the question to set up the headings. Don't make life any harder on yourself. Go ahead and use what you've got in front of you. Whether you use the names of the parties or the legal issues which you're dealing with, it kind of depends on how the question is asked, and also often what topic you're dealing with. So, for example, if you're doing civil procedure, which is typically talking about a lot of the different legal rules, the headings are often legal headings, like diversity jurisdiction. But if you have a torts question, you have a lot of parties suing each other, the headings are often related to the parties. So, for example, son versus shopkeeper. So let's go back to our example, the fact pattern we just read, and let's go ahead and mirror the question. So it asks, what crime or crimes is husband guilty, broker guilty, mechanic guilty? Okay, so let's go ahead and set up headings. Husband's crimes, broker's crimes, mechanic's crimes. That's how we're leveraging the question to help us get organized. So step 3. Let's break down what I call the mirror. You're breaking down what you've already created from the questions. Spend a few minutes to break down your basic outline into parts. You should look at the question again and identify how are you going to break them down. In this case, you're kind of going to break them down by legal concepts, which is the most common way of doing that. So legal concepts would be, okay, what crimes are they guilty of? Maybe solicitation, murder, and so forth. So what's that going to look like? When I break it down, I have husband's crimes, broker's crimes, mechanic's crimes. And under each one, I have each individual crime. Solicitation, conspiracy, murder of man. Same thing for broker's crimes. And then mechanic's crimes, just the conspiracy and murder of man. So how do I know that those are the crimes that they're guilty of? Well, again, that's because you know the rules and you've seen other fact patterns through the cases that you've studied. And by reading the facts really carefully, you can then figure out what crimes have been committed. Okay. So now we're going to IRAC each of these crimes. So write the issue, rule, application, and conclusion under each subsection. Okay, this is really important because I see this mistake made by 1L all the way through to bar takers. When you're told to write an IRAC format, it doesn't mean just one big IRAC for the whole question. So we wouldn't have just, husband's crimes and then a rule section with the rules for solicitation, for conspiracy, for murder. That's not what we do. We don't put all the rules together in one and then all the applications in one and all the conclusions one. It makes it really hard for the reader to understand what you're talking about because now they have to put things together. Okay. What it means is that for each issue that's legal rule presented, you'll have a small IRAC. Now, I just want to note that some schools that I've taught at, some schools they teach you and they want you to do like a CREAC format or a slightly different format. That's fine also. CREAC would be conclusion, issue, rule, application, and then conclusion. That's fine also if that's what they want you to do. Just make sure that each one is individually done. So what does that, so you need to decide what legal rule or rules you need. Write down the black letter rule. No facts from the fact pattern, just the black letter rule. Discuss the facts as they relate to the rule, state a conclusion, finish that little section, and move on. So here is our mirror plus the breakdown. So here's the IRAC. So H's crimes, first we deal with solicitation. The issue is whether husband committed the crime of solicitation. You don't need really long issue statements. Try to stay on point, try to stay brief, and you don't have to include 100 facts in that. Solicitation is the crime of promoting the commission of a crime. by encouraging or requesting another person to engage in a specific conduct that would constitute a crime. You notice the words that I've underlined? Those are buzzwords. You have to encourage, you have to request, you have to engage. Those are buzzwords for the rule, okay? That means in my application, I want to hit those things as well, make sure I proved each of those things. So here, husband requested the broker find someone to kill man. He also engaged broker because he paid him $5,000 to do the job. Therefore, husband is H is guilty of solicitation. And then we do the same thing. Here's conspiracy, right? So with conspiracy, again, you'll notice that I've underlined certain buzzwords in the rule for conspiracy, and I just have the black letter rule, no facts from the fact pattern. Okay, I have agreement to act criminally or unlawfully, overt act. All of these things are required in order to prove conspiracy. When I get to the application, I have here two people agreeing that there were two people agreeing to commit the unlawful act of murder, namely husband and broker. Again, I use specific facts. The parties committed an overt act but related to the conspiracy because husband paid broker $5,000 to find someone to commit the murder, and broker accepted the money. Therefore, H is guilty of conspiracy to commit murder. Okay. And I go on to murder. And I want to, again, point out the issue is whether husband is guilty of murder. And I point out it requires malice aforethought. Now here, there's also the issue of doctrine of transferred intent. Now, should I put the doctrine of transferred intent in a separate paragraph, or should I just go ahead and include it in the rule? It is a call on your part you'll have to make in that moment. But to me, when I did the application, I realized it's really that the murder and the doctrine of transferred intent really have to go together in order for me to think about it, because they logically go together so that I can get to the conclusion that I get to. So here, husband was a participant in the conspiracy to kill man because he paid broker to hire a hitman to kill man. Broker hired mechanic who adjusted the brakes on man's car so they would fail at over 50 miles per hour. Man's son borrowed the car. His brakes failed and son hit doctor, a third person, and doctor died. The auto accident was a direct result of the conspiracy. The doctrine of transferred intent makes it irrelevant that doctor died instead of man. Okay, so I've stated the rules and I've hit each of the elements of those rules in order to get to my conclusion, which is that husband is guilty of murdering doctor. Okay, when I get to broker's crimes, and this is a pretty simple fact pattern, but when we get to broker's crimes, they're the same crimes: solicitation, conspiracy, and murder. But there are different facts associated with the broker's crimes. Now, with regard to the rule, to save time, I said see above. You could also cut and paste the rule for solicitation and just put it right in there again, if that helps you to sort of work through the application. So in this case, I just emphasize the facts as related to solicitation for the broker, that he requested mechanic to cause the death of man by tampering with the car brakes in order to murder man. Therefore, he's guilty of solicitation. I do the same thing with conspiracy. And I get to murder. And again, I see the rule above for murder, and then discuss the transferred intent as well with regard to the broker. You will notice that I have the headings for each. Again, I've transposed those headings for each of the crimes so that my reader can understand exactly which one I'm talking about. We have the mechanic's crimes. He has the conspiracy. He didn't solicit anyone. So we have the conspiracy, and we have the murder. Okay. With regard to the rule, here are some tips that I have for you. You really need to state the rule without any facts from the fact pattern. This is a big mistake that people do, is that they feel they need to introduce the rule or they need to sort of segue into it. I get it. Again, I was a poli-sci major, and that was how I was taught to write poli-sci essays. Make sure you have a good segue, a good intro, and then, you know, a good conclusion that's handling the next issue. But that's not really what you're going to be doing here. What you really need to do is in each case, identify each issue and then make sure you state the rule without any facts in the fact pattern. Don't use examples when you state the rule. Like, if this happened, then this would be murder. No, you need to know the black letter rule for murder. Okay. You also need to handle one rule at a time. As you can see in my example, what I did was I handled, you know, solicitation, conspiracy, and murder separately. And that's because that's how I would argue it in court. If I was arguing in my brief or I was arguing in court, that's exactly what I would do. My client would be charged with these things, and I would argue each one separately. I wouldn't be putting them all together because they're not related charges in the sense that they are related to the fact pattern at hand, but they are things that I need to either prove with regard to the defendant or defend my client. Okay. Do not put rules together unless they're related to each other. So you saw that I had murder and transferred intent. I thought those went together, but I didn't think that solicitation and murder went together, so I kept them separate. Put all the related rules together in their own paragraph. Skip a line before starting the application section. You saw on my example how I had a lot of white space in between. You really need to do that. It makes it much easier for people to grade your essay. Oops. Move this forward. So here's some other things with regard to rules. So you have to actually know the structure of the rules. If you do and have an understanding of that, it's going to make your life so much easier when you're writing. You'll also know how to allocate your time. Okay, so there's all different types of rules, but here are the two basic ones I've come across. You have basically like single rules, and then you have multi-part rules. And multi-part rules come in two flavors. And the way I remember this is we have and rules, which are conjunctive rules, you know, the big English appropriate word, and rules, or you have or rules, which is like disjunctive rules. Okay. And an and rule is kind of like it's like baking. I don't know how many out there of you bake. I tried to do that as little as possible, but baking, it's like a baking rule. So if you had a baking recipe to bake a cake, you couldn't be like, I just don't want that, you know, I'm just not going to put that baking soda in there. We don't need as much flour in there as I think. 1 egg, 2 eggs, whatever. That's not how baking works. In order to make the cake rise, in order for it to work, you have to have all the elements of the recipe. The same thing is true for and rules. If you have an and rule, you need to prove each element in order for that particular legal concept to work. Now, when you do the essay, it might be that it doesn't work. You need to show that also. Oh, I have these 3 things, but this 4th thing is not there, so this is not going to work. Okay. An or rule is more kind of like a stir-fry recipe. I mean, stir fry, you could have, 5 or 6 different types of veggies and a protein. Okay, you don't like bok choy, fine. You leave bok choy out, you still probably got a stir fry. Okay, so that's the way you need to look at it. So here's an example of a simple rule, just a plain out simple rule. So the question is, Maria files a complaint in federal court against Donnie on June 1st, 2011. Donnie filed a response on August 1st, 2011. What result for the defendant? The issue is whether or not a default judgment can be filed against Donnie. So here's this really simple rule. It's like a time rule, okay? Under the federal rules of civil procedure, a defendant must respond to a complaint within 21 days. Failure to respond in a timely manner will result in a default judgment against the defendant, okay? Application. So you got to do the timings. Here, Marie filed a complaint against Donnie on June 1st, 2011 in federal court. Donnie filed a response on August 1st, 2001, 60 days after Marie's complaint was filed. Conclusion. Therefore, because Donnie failed to file a timely response, a judgment of default can be entered against him. Pretty straightforward. Nothing really complicated there. Okay. Now we have multi-part rules. These can be a little bit trickier to deal with. Again, first you determine if it's an and rule or an or rule, like baking or stir fry, okay? And again, for an and rule, you must prove each element. For an or rule, you don't have to prove each element, but you talk about as many as are relevant given the facts that you have. You also have some rules that are hybrids, and so make sure and understand the structure of the rule. This will help you craft your answer. So what does that mean? It means that like in an and rule, because if it has 4 parts you have to prove, you may have a more extensive answer because it's going to take longer to write and prove each element. Number the parts of your multi-part rule in the rule statement and the application so that they correspond. Now, one of the things I really like about the BarMax outlines is that a lot of these multi-part rules are already numbered for you. And I think that is so extremely helpful when you're trying to figure out what you need to write, how much you need to write. Okay, so here's an example of an and rule, like the a very typical one, which is negligence. It requires duty, breach, causation, and damages. Here's an or rule. Federal subject matter jurisdiction can be based on federal question properly pleaded in that complaint or on diversity jurisdiction. You need one or the other, not both. Here's an example of a hybrid rule. This is a venue rule. In diversity and federal question cases, venue is proper in any district where 1A, all defendants are domiciled, or 1B, where a substantial portion of the claim arose, 2, there's a subject matter jurisdiction over the claim, and 3, there is personal jurisdiction over the parties. Okay, so that one's going to be a little bit different. When you look at your facts, you're going to say, okay, do they fit 1A or 1B? And then I've also got to have 2, and I've also got to have 3 when I'm talking in my application. Okay. With regard to the and rules, they can be organized in different ways depending on how complicated they are. A lot of and rules, like negligence, for example, are high point value topics on your essay because they are really requiring you to go in depth into each element of the rule. And negligence in particular is very complicated because each element of negligence actually has its own little rule also. So there's different ways to do this. I have my preference, but another tutor or another teacher might have a different way of doing this. So I'm going to show you both ways. So we can do it this way, which is we do the issue is, whether so-and-so is negligent. I put the big rule, negligence requires duty, breach, causation, and damages. And then I talk about duty. What's the specific rule for duty? In this case, we're saying where defendant's conduct creates a peril, there's a duty to act. And then we talk about breach. What's the rule for breach? Where defendant fails to conform her conduct with the applicable standard of care, she has breached her duty of care. What about causation? A little more complicated. A successful showing of causation requires the defendant to prove actual causation, but for causation, and proximate causation. And then proximate causation has its own rule. To prove proximate causation, plaintiff must prove that he was a foreseeable plaintiff, the injury was a foreseeable injury, and there was no superseding cause of the injury. A plaintiff must, and then for damages, a plaintiff must have suffered damages. Now, when I go to the application, remember, I have to talk about each element: duty, breach, causation, and damages. Here, there's a duty because. What are the facts? Here, there was a breach because. Here's this actual causation, proximate causation, damages, and so on. Okay. When you have a complicated rule like negligence and you put it all into one rule section, I'm not saying that that's wrong, but for me personally, I get really confused because I'm not really sure like which things I'm supposed to talk about, and I can forget stuff. So when I have something like this, and I know negligence has a high point value, I personally like to break them down into smaller pieces. So as you can see here, I put down the big rule for negligence: duty, breach, causation, and damages. And then I do a little sub-IRAC. And I have duty, and I deal with it, IRAC. Then I do breach, and I do the same thing. And that allows me, when I do this for each one of these elements, it allows me to just think about that particular element and the facts related to it. And that just makes things simpler, and I don't forget stuff. Because the last thing I want to do is like forget to mention damages or forget to mention proximate causation and then lose points because of it. So once I get through damages, I have my IRAC, and then I have my big C, which is now I'm going to answer the question. I mean, if I have all of the elements, duty, breach, causation, and damages, then I can say, therefore, so-and-so is negligent. If I don't have all the elements and we're like, well, they're not negligent, or I can't prove negligence. Okay. With regard to the application, so I suggest that you start the application with here. Why is that? It makes it easier for your professor to grade your essay, because they know every time you say here, you're going to start talking about your application and your facts. It also is a good way to train your mind. It's a good cue for you as well that, okay, now I'm going to talk about my application. Use specific facts from the fact pattern. Now, I've sat in on a lot of professor meetings and issues about students' grades and why didn't it do well on the exam and so on and so forth. And the biggest complaint about student writing is that they don't use the facts. All they state is the rules and the conclusions. And you will lose points if you do this. Professors, it's their big pet peeves that I've seen over the years. Okay. Why is that? Because your client's facts are really important. You also need to show your logic. I mean, if this is the rule and these are my client's facts, this is how I got to the conclusion. Okay. It doesn't matter a lot of times if your conclusion is not exactly the conclusion that the professor has on their model answer or their grade sheet, but you have to show your logic. How did you get to this conclusion? Anyway, that's what your client is paying for, right? They're paying for your advice. They're paying for you to look at their specific facts and come up with a conclusion. And they're going to ask you, well, how did you get to that conclusion? That's also what the essay is training you to do. Okay. Link specific facts to the elements of the rule that you're trying to prove. So there was a duty because, and then what are the facts? There was a breach because. And you notice my use of because it's a very easy way to link the two together. So you take an element of the rule, you stick because on it, or since or by, and then you put down the relevant facts. Another thing that students do is they want to talk about, a lot of times, the rule that they know, so they add facts to the fact pattern. Don't add facts to the fact pattern. You couldn't add facts to your client's fact pattern if they were in front of you, or their client's facts that were in front of you. Okay, so don't start going down the road of adding facts and, well, what if this happened? But it didn't happen. What you have is the facts in front of you, and you need to do that, and you need to deal with them. Now, if they're facts which you think might be possibly lead you to some sort of legal conclusion, then if you have time, go ahead and pursue it. But don't go down a rabbit hole and add facts and just keep talking about what you want to talk about. Okay. So as we saw, this is what I did for conspiracy. This is how I linked the rule to the facts. And you can see in the red, we have agreement, overt act. And look, the parties committed an overt act related to the conspiracy because husband paid broker, so and so and so, and on with the facts. It's a very easy way to link the two, and it makes your essay so much easier to read. It also shows that you know how to use the rule. Okay. With the conclusion, start the conclusion with therefore or thus. The conclusion should be relatively short. Don't repeat all the facts you presented in the application. I mean, you've already talked about that, so you don't have to repeat them all. Okay. Don't introduce new ideas or a new legal argument in the conclusion. You have to be, really, really disciplined about this, because it just confuses people when you just add something in the conclusion, but you don't have any rule to support it. And they're like, what is this person talking about? Don't talk about the next issue you're going to discuss. Just create a new heading and then the issue and talk about it. I know that's kind of counterintuitive to all you English, poli-sci, history majors out there, but it's a little bit different game in law school. Just answer the question you posed in the issue statement. Don't try to answer a whole bunch of other questions, and make sure you're answering the question you were asked, that's asked of you. Don't answer your question that you're asking yourself. Make sure you're being responsive to the question, your client's question. Okay, so here's an example. The issue is whether Anna has a right of reentry to Blackacre. Under state law, actions to recover the possession of real property should be brought within 10 years after the cause of action accrues. Here, 3 years ago, the condition was broken when the school began using Blackacre only for administrative offices. Here's the conclusion. Therefore, Anne will have 7 more years to bring a cause of action under her right of reentry. As the little girl says, yes, we like this conclusion. Here is a conclusion we don't like. It's talking about adverse possession and all of the elements. And then we get down to the conclusion, and they've talked about all the different elements of adverse possession. They get down to the conclusion and they say all the elements over again. Therefore, Hart may claim an interest in the land under the theory of adverse possession because his use was open and notorious, hostile, exclusive, but we already proved all of those things in the application. And then on top of that, they said Hart would also have a claim for an easement. Were we talking about an easement? No, there's no rule for the easement. And that might be the next thing we talk about, but we're not sticking that in the conclusion. How would I rewrite this? Therefore, Hart has title to the land by adverse possession. Yes, that's what we're looking for. All right. So step 5, be obvious about your answer. So these are just some things, that makes it a little bit easier to read. And that I've heard professors talk about time and time again. So one of the things I showed you in my examples was to underline key concepts and facts, including those in the headings. Keep your paragraphs short. Don't ramble on. Make sure that you're talking exactly about what that little IRAC is about, and don't make them, pages and pages long. Just prove the elements of the rule. Keep your sentences short. People always write really long sentences, like as if their train of thought is what they're going to put on paper. Keep your sentences short. Long sentences are much harder to understand. When you have a tired professor reading a lot of essays, you want them to understand you so they can give you the most number of points. Leave white space, so skip lines between paragraphs and leave margins. Your professors are reading a lot of essays. Give them a break. Give them a break visually, and there's nothing more depressing than getting an entire paragraph on one sheet of paper and with no breaks in it. Because like when I'm grading that, I can't find anything. Okay. Write legibly if you're handwriting. Just remember, if the reader can't understand what you're saying, you won't get all the points you deserve. Okay. We talked about starting the application and conclusion with therefore. Underline them just so they're easy to find, again, to award you points. Don't underline too much. I used to do that, so I'm putting that down as a suggestion. You underline the main buzzwords, short phrases or words. If you need to underline more, your paragraphs are probably too long, so reconsider that. Okay. As far as short paragraphs, it's a matter of discretion, but keep them relatively short. Okay. You shouldn't have more than one or two key concepts in a paragraph. Should never take up a full page. I just said that. Don't write overly long sentences. Careful about run-on sentences. Big pet peeve of a lot of the professors I used to talk to. Watch your grammar and spelling. If there's too many issues, then it becomes distracting and it becomes hard to understand. Some professors are a little bit more annoyed with that than others. Okay, I will just remind you that, you are training to give people advice and to solve their problems. And that's what these essays are. And so I'm going to leave you with this quote from Abraham Lincoln: lawyers' time and advice are his stock and trade.
Thank you.
I'm happy to take any questions.
Yes, we definitely have time for Q&A. So if people have questions, I want you to post them either in Q&A or chat. We're looking at both places. So yeah, go ahead and type them in there. I just want to say, first of all, thank you. You had a lot of examples and I saw your presentation. I didn't know how long it would take, but you went through it and made it super clear. So thank you. I like that you said, use the facts like you're talking to a client, because I have had people come to me for legal advice, as have you, and the answer could be really, really clear. Like, no, you didn't file by the deadline, so you're not going to get anything, right? Something like that. But they're like, well, what about this fact? And he insulted me and this happened and that happened. And like, they want you to know that they heard your facts. You have to use their facts, Well, even though the shower drain has been clogged for 2 weeks, the fact that you haven't written to your landlord about it means that you can't just go and withhold rent, because of this rule, right? Like, they want to know that you heard their facts because they think, surely that's determinative. That's going to control the outcome. And it doesn't, exactly. Right?
I always tell people, think about who's paying your bill, and they want you, they're paying your bill and they want to know that they're important. Think about it that way.
Yep. And here it's the professors. Now, it's not fair because you're paying their bills, but they are giving you your grades. So you want to give them what they want. And the other great piece of advice, Lavanya, that you mentioned, and I do it to bar students, you do, we have other bar instructors, the because. Okay, you've got basically, elements, because, fact. You've got some legal piece, breach of duty of care, because, fact. What comes after the fact should all be words directly from the professor's question. If you're not getting those words in there, yes, I was a professor. It is maddening when you get these conclusory answers. Well, here's they'll repeat the facts from the problem and tell you the rule, but they won't tie the fact to the rule. And then they just give you a conclusion, like, how'd you get there? How'd you get there? We want to know how you got there. We want to know that you understand which facts fit which element of the rule. So that is really, really good advice. And short sentences, oh my goodness, I wish somebody had told my students that. I didn't tell my students that. I should have. Because sometimes it seems like they lost their own train of thought in the middle of a sentence.
And I think in the grading that we do, for bar grading, with BarMax and also working with other students, that's critical. I think all the tutors point that out to people. Being clear, being concise, being organized in your writing, and getting that feedback, I think, is really invaluable that BarMax has.
Yeah. So anyway, thank you. I think this is really valuable. Now the students are saying it's valuable and they want to see it again later. So here's what we're going to do. We take some time to edit these a little and get them posted to our YouTube channel. Which I did post a link to that. Is it still there? It is. And there is a 1L workshop playlist on there that has all the things that we've done for 1L so far. So this will get added to that list. This link on the screen right now is to unlock 1L. And we also have another link for those of you interested in becoming BarMax reps at your law school. There is an application you can fill out. If you are selected as a BarMax rep, you get a free bar review course, lots more good videos in addition to our top of the line lectures, all practice problems we believe in teaching from real past practice, real past exams as practice, both for essays and multiple choice. We believe in an active study approach. We teach that. So we think it's a pretty streamlined, and I can't say stress-free because studying for the bar is stressful, but definitely lower stress way to prepare for the bar exam than the other options out there on the market. So those are two things you want to consider. Now, here's why you want to unlock. Can you stop sharing for a second and I'll jump over into mine? Oh, and check and see if anybody has any questions. You can use this time to answer them because I'm going to share something. And were there any questions in the chat or Q&A? I don't think so. Okay, is my screen showing?
Yes.
This is what you get with 1L. And, we've shown these before. These are our lectures and outlines. So, for example, contracts, 7 sections here. They're pretty short. You can go over everything about parallel evidence and contract interpretation. You may have covered 12 cases. And they're all swimming in your head. And you say, I just want someone to tell me what the rules are, what they mean. Then you just go watch that 41 minutes and you'll have like that summary, right? So that is super helpful. And we have it for all of these courses listed here. Most of which you're taking your 1L year. We also have the Law in a Flash flashcards and the case notes legal briefs, which can be useful to make sure that you've understood a case that you've prepared for class. But more relevant today, we have practice essays. So let's go back to contracts again. You can see that here we have a question that you can work on, and it has a lengthy analysis after. So after you do it, you can see whether or not you understood. Okay, I don't kind of want to spill the beans because I want you to work through these questions yourself. Because if you can spot the issues and state the rules, look in that mirror, figure out what the questions are, break down those, use the mirror and then break it into subcomponents to organize an answer and take a crack at drafting it. Even if you take some extra time, or at least try to write a good comprehensive outline for it, then read the analysis that comes underneath. And boy, oh boy, that will really, really help you to be quite solidly prepared for your exam. So we have a few that cover some heavily tested material for each subject. Okay, so there's 5 here in contracts. That's, quite a bit of good review material for you, especially if your professor has not provided past exams of her own. Okay. Well, any final thoughts to add, Lavanya?
No, I just, like I said, I hope it's helpful. I wish somebody had told me this stuff 1L year. That would have been nice. It took me probably all of law school and then the bar exam before I actually figured it out. So
Yeah.
I hope that it was helpful.
Yeah, I think by the time I was done with law school, I had it down, but it would have been nice if I knew a little bit more about how I was supposed to write these exams and how I should have been studying for these exams my first semester. Because I knew a lot of law and my grades were not at the top, so that was rough, really knowing what's going on in class and then not having the top grades, because other people knew how to write these answers.
Yeah, exactly.
in a way that, showed their work, that applied the facts. I can remember.
Right.
I said something was a requirements contract without explaining why. And I'm like, duh, because it's obvious. No, my contracts professor was like, what happened? Which essay was yours? Like, how come you don't have the top, at a high grade?
Right.
So,
there.
It's a tough memory. It's like
it is a tough memory.
25 years later, and I'm thinking about it. Yeah. So, guys, this was really, really useful stuff. And like we said, the session will post again, and we have our other 1L sessions for you there in that same playlist for you to look at when you get a chance. And thanks for joining us tonight. Take care and good luck on your exams.
Good luck.
Bye.